It's my emotional touchstone. There's another Brenda Thomas. There's another one close to me in Colorado.
Welcome back. Before I turn the podium over to Michael Scharf, I would like to recognize another one of our sponsors. I think Cameron Hudson is, there we go. Cameron Hudson is representing the United States Holocaust Memorial Museum. The Holocaust Memorial Museum has been a part of the dialogues. I believe this may be the 5th year, something like that. But it is an honor to have them join as part of the dialogues. And so, Cameron, would you like to take a short minute and tell us a little bit about the museum?
Sure, thank you. And honored to be here among such an incredibly august crowd. Even more important for the Holocaust Museum representative to be here in Nuremberg, this documentation center and others like it, we have partnerships with across all areas of my museum's work. I represent the part of our museum that works on contemporary issues. I run the Center for Genocide Prevention, which our founding chairman, Elie Wiesel, thought needed to be a core mission and core mandate of our museum, not simply to commemorate the past, but to learn from its errors and apply them to future generations. And so that is the work of my center. We engage in policy work with the U.S. government. We engage in research with many of you and others in the field trying to strengthen the norms and institutions around genocide prevention. So I'm just grateful for the opportunity to be here and happy to announce that we are launching, if you haven't seen this literature out there, the Ben Ferencz International Justice Initiative in partnership with Ben Ferencz, really to try to make the connection between justice and accountability and prevention of mass atrocity crimes. So this is a new initiative for us, and we're thrilled to be here to launch it. So thank you very much.
Okay, thank you. I would now like to invite to the podium Michael Scharf, Dean of the School of Law at Case Western Reserve University, a university that I'm honored to be a part of in a small way. But Case Western Reserve University has been part of the dialogues as a sponsoring organization, I believe, from the very start. And it is an honor to invite Michael to the podium to lead probably the hardest roundtable of the day, I would say. This is a tough group up here right now. And so I invite Michael to the podium. Thank you.
I don't know, compared to deaning, which is like herding cats, this is child's play. So I just realized from John Barrett's speech that I am the same age as Robert Jackson was when he was here, and that blows my mind. But if you go back 23 years, before my hair turned gray, before I had a beard, before I was a dean or a professor, I was working with Jane Stromseth and Todd Buckweld and Paul Williams at the State Department Office of the Legal Advisor. And it was handed to me to be part of the team to help create the Yugoslavia Tribunal. And that launched me on my journey, which has gotten me to this point where I get to converse with my heroes, the international prosecutors. So, as Jim Johnson said last night, this is a group that doesn't need a long introduction or really any introduction at all because you have their bios and their positions and their experiences speak for themselves. But just to go down the stage, we have Fatou Bensouda, the Chief Prosecutor of the ICC, Serge Bremertz, the Chief Prosecutor of the Yugoslavia Tribunal and also of the Rwanda Tribunal's residual mechanism. We have Hassan Jallo, the Chief Prosecutor of the Rwanda Tribunal. We have Brenda Hollis, the Chief Prosecutor of the Special Court for Sierra Leone. We have Nick Kmuchin, and I always mess up your name, and I apologize, but a wonderful Chief Prosecutor of the Cambodia Tribunal, and then Eckhart We're Humph from the Special Tribunal of Lebanon. A wonderful group today, and we've talked about how we want to present this information to you. In the past, I've asked an open-ended question, and we've gotten very long open-ended answers. So Jim Johnson said, listen, you really, this year, need to link this to the Nuremberg experience, the Nuremberg legacy, and let's ask very pointed questions. Do what you do on your radio show. So we've conversed and talked about these. What I'm going to do is ask specific questions to each of them, and some will be questions for more than one, and we're going to zoom through those, and hopefully at the end, there will also be time for Q&A from the audience. When does this end, just so I can keep track? 1 p.m., okay. So we're going to do that. Now, Nuremberg is why all of these international tribunals are possible. And everybody who is in this room who believes in this field is a fan of Nuremberg. But we also remember that when the prosecutors returned from Nuremberg, they returned to a very critical reception. You had people like Senator Taft writing a speech really excoriating the due process norms at Nuremberg that then John F. Kennedy puts in his book, Profiles of Courage, which makes it a very popular conception. And it is true that Nuremberg was an experiment, and like any experiment, any first effort, it had its criticisms, it had its problems. And I think what we've learned largely is that we've grown over the 70 years and solved a lot of those problems. But what I'm going to use as my way of asking these questions is to ask questions related to some of the criticisms of Nuremberg and related to things that are happening at each of these tribunals in the last year. So to bring that up as current as possible. So let's begin talking about what Bill Schabas has labeled in his book, The Crime of All Crimes, genocide. You know, contrary to widespread belief, and I suppose everybody in this room knows this, but the general population wouldn't so much, the Nuremberg Tribunal did not charge or convict the crime of genocide. I think it was actually Don Ferencz in his trial, Ben Ferencz, Don's dad, at his trial, that used the word for the first time from the prosecutor's bench. But there have been some really interesting developments in the crime of genocide in the various tribunals that I thought we'd start and kick things off with. So we'll ask Hassan, Nick, and Fatou about these. Hassan, first of all, since our gathering in Chautauqua a year ago, the appeals chamber of the Rwanda Tribunal has issued its final decision affirming the conviction of Pauline, and now if I'm bad with your names, think about how I'm going to do this one, Nira Masahuko, right. And she's convicted of genocide and rape. So I was going to ask you, what would you say is the significance of that final decision of your tribunal?
Well, the Rwanda Tribunal has been the premier genocide tribunal. It's the first to have dealt with, in a judgment, with the question of genocide, setting out this element, etc. It has tried more genocide cases than any other. Niramashuhuko was the last of the cases, what we call the Butare case. Niramashuhuko was the minister at the time of the genocide in the interim government. And ironically, she was the Minister of Family Affairs and the Advancement of Women. She's the only woman who's been indicted at the ICTR and convicted. She was convicted for... Please speak a little more.
Yeah.
She was convicted of ordering the killing of Tutsis, convicted of genocide in respect of the ordering the killing of Tutsis, and also convicted of genocide in respect of rapes committed by her subordinates who were members of the ruling party in Taramwe. In a way, I think that being the last judgment also emphasized very much the approach of the Rwanda Tribunal in dealing with this question of sexual violence as a tool for genocide. I think if you recall, the first judgment of the ICTR, that is Akayesu, also was a landmark in terms of the link between this sexual violence, rapes on the one hand, and genocide. And it demonstrated how these acts of sexual violence can constitute genocide. And the last judgment of the tribunal also very much emphasized that point through the conviction of Niramashukuko. And that's why I think Niramashukuko is such a landmark case.
And interestingly, she's the first woman in history to be convicted of this crime.
Yeah, she is the first. She is the first.
All right, so Nick, I've been following events out there in Phnom Penh. As you know, I was a colleague, a subordinate of Robert Petit during my sabbatical there. So it's one of my favorite tribunals to watch, one of the most fascinating things. And you guys have had history lessons over the summer. You've had historians talking about whether the Khmer Rouge actually had the requisite intent in targeting the Cham and the Muslims and the ethnic Vietnamese to prove the crime of genocide. So basically the historians are up there on stage. Can you tell us a little bit about how that unfolded and what the outcome of that has been?
Well, the historians have been limited by the court in what they're supposed to give opinions on. So they are not supposed to give an opinion on the ultimate question of whether genocide occurred, for example. But there have been historians that have testified who interviewed many of the victims and some perpetrators of the crimes and talked about basically the facts about what happened during the regime. And specifically what's at issue, there are two separate genocides charged in the Cambodian courts. One is and they're both of small minority groups. These groups were killed in the thousands or tens of thousands, while in total, in the whole population, about 1.9 million is a rough estimate of people were killed, most of those being Cambodian ethnicity Khmers. But there were two groups that were particularly targeted: the Vietnamese, a traditional enemy that was particularly loathed by the Khmer Rouge. In the initial years of the regime, they were exported, they were sent back to Vietnam, and then we really relied more on witness testimony. There was one of the generals of the Khmer Rouge who admitted that, yes, if they hadn't left in the first 2 years, the orders were to kill them. The policy was to kill them all. So maybe 10,000 or so Vietnamese were killed, but that was all that was left in the country. And through various statements of the accused, we argued that we argue and will argue the intent to exterminate that group in whole or in part in Cambodia existed. Another very interesting genocide in our case is of the Cham Muslims. This is an ethnic group and a religious group. So they were practicing Muslims. Statistics, one historian testified that in his estimate, about 40% of Cham were killed, and this was higher than the rate of Khmers, Cambodians, which was about 20 or 25%. But the key thing that we've argued is that the Genocide Convention says destroy in whole or in part a group as such. The Cham were practicing Muslims, and when the regime took power, they abolished religion, and particularly Muslims and others, but Muslims were not allowed to pray. They were not allowed to dress in their traditional dress. They were not allowed to speak their own language. They were not allowed to do any of the ceremonies of the religion, and they were often, very, very often, forced to eat pork. So we will argue, and that the intent was to destroy the Cham as such. All of those who asserted their identity as a Cham, wanted to practice their religion, were killed. We noted the statistics that particularly religious leaders were almost all wiped out. That this would destroy, particularly when you're talking about a religious group, if all those who practice the religion are killed, the intent is to destroy the religion as such. So we'll see how the court will eventually deal with that. But the historians were brought in more to talk about what they learned from their interviews with victims and perpetrators, supplementing the testimony that we also have before the court, both live and written statements of many victims.
Nick, will the defense bring in their own historians? You'll have a battle of history?
Well, the defense has proposed various historians. It's a civil law system, so the judges pick the witnesses who testify. And we've never opposed, I've never opposed any of the witnesses that the defense proposes. Some have been reluctant to testify, unfortunately, but soon after I get back, I'll be examining a defense expert witness.
Excellent. Now, Fatou, the United States has labeled the actions of ISIS in Syria as genocide. And I know you've announced that there's an investigation going on about ISIS, and I'm wondering if you can give us an update on the ICC's investigation on ISIS and whether the genocide allegation has had an effect on that.
The ISIS crimes, or alleged crimes, as we call them, undoubtedly is something that is of concern to the international community. They are very serious allegations of atrocity crimes that are being committed. The Rome Statute, however, has a jurisdiction which is very specific and it's very, very defined. My office has been receiving, just for you to know, that since 2014, my office has been receiving information and receiving requests for intervention by the ICC. But as you know, given the fact that both Syria and Iraq are not states parties to the Rome Statute, we do not have territorial jurisdiction in these two countries. I have, however, been looking at it myself with my team very closely as to, with respect to personal jurisdiction. Because what you see today happening and the allegations of these crimes that are taking place is that there are nationals of states parties who are found amongst the ranks of ISIS. And we've looked at that very closely, and we have also called for the states who have their nationals amongst the ranks of ISIS to provide my office with any information, further information that we have. But I wanted to just also point out that given the office's policy for a long time now of the person bearing the greatest responsibility for those crimes, as well as the principle of complementarity, I have decided, we've really looked at it closely, to ICC being a court of last resort, I mean. We've looked at it closely, and in the statement that I've issued, I believe in 2015, to say that that jurisdiction that ICC could possibly have, my office could possibly have over the crimes that are being committed over those nationals of states parties who are found amongst the ranks of ISIS is very limited and very narrow. And at the moment also we have found, or at least the information we have been receiving, we've seen that those who are occupying the highest ranks amongst ISIS are not necessarily, there may be one or two exceptions, but are not necessarily those who come from the states parties, ICC states parties. It's mainly Syrians or people who come from Iraq. I'm not saying that there are no others that are from states parties, but this is at least what we have seen, the trend that we have seen. And therefore, the jurisdiction that we have is still very narrow. But that does not mean that we do not continue to ask for the information from states parties to provide the office. It is important that we continue to look at it and also to work, if possible, very closely with those states parties with regards to their nationals that have committed or are alleged to have committed these crimes.
Has there been any discussion of a Security Council resolution on the leaders of ISIS, referring those to the ICC?
Well, I know that there has been some initiatives taken by certain states parties, but as you know, these decisions are taken independently of my office. But I do know that there are states parties who have taken up this issue and are trying to see whether there could possibly be a referral from the UN Security Council to the office for the crimes, because that way, of course, the jurisdiction and the way we could intervene becomes much larger than what we have currently, which is very limited.
But ultimately, it's a...
Mike, can you ask her about Libya and Serbs and ISIS there?
Sure. Steve, why not? So would you comment also on Libya and ISIS?
No, I'm glad, Steve, that you've asked that question, because the office is actually, and maybe this was something I was also going to include in my remarks, the office is also, as you know, looking at current crimes in Libya. In the last report I did to the UN Security Council, I indicated that we will not only focus on the crimes that have been committed by the Gaddafi regime, and during that period, the first part of the conflict, but we have seen that these crimes continue to be committed in Libya. We see the atrocities that are committed, and we have, of course, got information that members of ISIS are also allegedly involved in the commission of those crimes. So this gives us a window in which we could look at the crimes that are committed by these people who are alleged to be part of ISIS in Libya, because already we have jurisdiction with respect by the referral that we have got from the UN Security Council. So to that extent, we could also expand our focus. We could also expand looking at other crimes that have been committed, including the new crimes that are allegedly committed by members of ISIS.
So one of the things that happens to international tribunals is they get criticized from all sides for every decision. And this was true of Nuremberg. It was criticized both with respect to who was indicted, but also who was not indicted. And there's always been a political background to international justice. That's not to say that the prosecutor's office is politicized, but there is a background. So the Yugoslavia Tribunal, for example, was criticized for first delaying and then later rushing the indictment of Slobodan Milosevic. The Special Court for Sierra Leone was criticized for indicting Charles Taylor, and then there were those who criticized it for not also indicting Muammar Gaddafi. The ICC was criticized for indicting the now president of Kenya, a case that has been dismissed, and it's been a very challenging case, I know, politically. The Cambodia Tribunal has struggled bringing cases against individuals who may have some association with the current government. And there are press reports that the Special Tribunal for Lebanon may be closing in on an indictment of Syrian President Assad. Those might be wildly wrong, and Eckert told me he cannot talk about that issue at all. But I wonder if Serge, Brenda, Fatou, and or Nick would care to comment on the issue of courts and international politics. And try to keep it relatively brief. We'll start with Brenda.
Yeah. Thank you. I think this is an important topic, and I think it's one that we need to be very clear about. And when we look at critiques of these international courts, no matter what you do, someone is going to be critical of it. And so the issue becomes, what is the proper perception of an international criminal court? And I think it's much the same as what is the proper perception of a domestic criminal justice system. And it cannot be tied to political whims or political desires. Because as soon as you base your decisions on politics, then where do the victims go for justice? Because justice becomes basically a slave to situational politics. So in my view, the perception that international courts should work to achieve is that you are doing your job professionally with an informed database according to your mandate. And I think the answer that Fatou gave to one of the earlier questions is exactly what a court should do. Is it within our mandate? Do we have the law and the facts to support our actions? And that is the only perception that we should be promoting. And there are ways to promote that. Outreach is a very good way to promote that. Informing people about what your mandate is, what it is not, and also having strategies for investigation, for prosecution, and then basically implementing those strategies through criteria and factors that guide you in carrying out those strategies. And I think when we look at the current leadership in the ICC OTP, they are far in advance of the other courts, because the other component of having these strategies, criteria, and factors is, to the greatest extent possible, be transparent about what they are. so that the public knows why you are acting and how you are acting. And I think that is the perception that should be out there for the courts.
Does anybody else want to add to that, or? Feel free, sir. Go ahead. Yes.
Sure. All our tribunals have been criticized many times for many different issues, and you mentioned the Milosevic case at the ICTY, and I remember in the early days, one of the big criticism was, well, ICTY at the beginning has indicted and prosecuted a lower level or mid-level perpetrator, where the tribunal should have really stayed on focusing on those who bear the greatest responsibility. If we are looking back today, 20 years, we still see this criticism, but it is only thanks to the prosecution of a number of mid-level perpetrators that we got all the evidence we needed to go for the big guys, and that's why we have a number of very successful convictions in relation to Karadzic, hopefully Mladic, and many others, because we had the possibility to build up the chain of command, which I think was very important. So a case selection, who you are prosecuting, is a very difficult one. And where we think that this kind of mixed approach, top-down, bottom-up, is the right one. You know, we speak about Nuremberg. I remember at one of our discussions when Ben Ferenc was there the first time, I asked him, I said, you know, we have among prosecutors all this discussion about, you know, who to prosecute, how many, what is the gravity threshold, and I asked him this question. I'm sure many of you have asked him, so how have you selected your 23 indicted persons? He said, well, we had space for 23 persons, so we went for 23.
Right.
So we're always thinking about very sophisticated arguments, and well, there was space for 23. That's the criteria like others. And we always discuss also the scope of the indictment. You know, what are you putting in indictment? We all agree that Milosevic, he died before the end of his trial, and indeed it was a very heavy indictment in relation to crimes committed in Bosnia and Herzegovina, in Kosovo, Srebrenica, the hostage taking of the Blue Helmets. So with a very large indictment. Later on, the judges passed rules to limit or to manu militari force the prosecutor to reduce the indictment by 30%, and we have done it on a voluntary basis later on. And we had this big debate when Karadzic and Mladic were arrested, where many were asking us to really cut the indictments. We cut them by 50%, having a lot of meetings with victims' organizations to explain why certain municipalities would not be any more in the indictment. So in terms of expectations, you know, those who are financing the tribunals want smaller, shorter, leaner trials. Victims, rightly so, are expecting the broadest possible. And the challenge is to find this compromise between having a trial which is much more than in a domestic level, a trial which is showing the magnitude, the importance, and the gravity of the crimes committed, but at the same time being manageable. For example, for Karadzic and Mladic, we reduced from 200 incidents to 100. And last small element is timing. You know, we all know justice delayed, justice denied. Well, in the international field, it is different. You know, there are moments where you have zero chances of being successful, and others, which is the right moment to move forward with an indictment. So just to say that there are so many decisions to be taken that it's very, very easy to criticize whatever decision we are taking.
Let me ask as a follow-up whether there's diplomatic pressure to indict all sides of a conflict. So I know with the Yugoslavia Tribunal, they started with a Serb indictment, first trial, then a Croatian, and then a Bosnian Muslim. And I know that diplomatically and publicly, people at the time said, well, that was really wise, because that was good for reconciliation, to have prosecutions of all sides. Now, in other places, like in the Ivory Coast, self-referral, there's criticism because only the former regime and nobody in the current regime is getting indicted. How did the idea of indicting different groups, you know, the pro-government, the anti-government, in terms of how it fits into diplomacy, how does that unfold? Does anybody want to comment on that? Hassan.
Yes, the selection of targets for investigation and prosecution is one of the most difficult areas for any prosecutor. And none of our tribunals has escaped criticism about our final list, that we included some, we excluded others. It's because of the nature of the system itself that international criminal justice is selective it has to be selective because it can't prosecute everybody. You have to make a choice as to who to select. I think the important thing is, as a prosecutor, when you do select, you have objective criteria to guide the selection process. You have a procedure to do so, and you're transparent about it. And you're transparent about the whole process. At the ICTR, when we were faced with the completion strategy, we spent actually days debating the criteria for selection of cases to do, and we agreed on them. Steve Rapp was there, James Stewart was there, and they were very, very all helpful. And once we agreed on these criteria, then it was the task of a small committee now to comb through the cases and see which cases met those criteria or not. So that helps you. I think that's the best protection a prosecutor has. Objective criteria, transparent process, which is made public as well. There's no interference. I mean, speaking for the ad hoc, for instance, on this issue of prosecuting both sides, in our case, for instance, we would like to refer to the fact that there was also the RPF side. The Security Council did make a reference to that issue in a resolution 1503, I think, but it was very, very careful. It never asked the tribunal to prosecute members of the RPF. It asked the tribunal to investigate and left it then to the discretion of the prosecutor to decide whether, in the light of the evidence and in the light of the law, there were any cases to prosecute. So there was that guidance sort of from the Security Council that in addition to the cases we were doing, it was necessary to investigate the allegations against the RPF, which we did. But the Council did not overstep its boundaries by interfering with the judicial process. It left it now to the tribunal to decide whether there were cases to do or not.
Now, to change the subject for a second, in our wonderful keynote this morning, we heard a great background story about how the court decided to indict for the first time the crime of forced marriage. And as everybody knows, one of the criticisms of Nuremberg was that it was applying ex post facto crimes, in particular the crime of aggression, which had never been prosecuted before. And your courts have all had to grapple with new innovative crimes and evolutionary crimes. Let me ask Nick and Brenda this. So Nick, you've charged a different type of forced marriage, but using the same term. Brenda, your tribunal convicted forced marriage with respect to the phenomenon of bushwives. How are those two crimes of forced marriage different and similar? And how did both tribunals deal, and yours, Nick, currently dealing with the issue of the ex post facto attack?
Thank you. Well, of course, the defense challenged that this crime of forced marriage was not part of customary international law in 1975, the period of jurisdiction of the ECCC. But the case has, the crime has already been it's already been confirmed in some litigation at the court that it falls into this residual category of other acts, now I'm forgetting the terminology, other inhumane acts for crimes against humanity. And this has been upheld in a lot of jurisprudence that said that basically when the acts reach the level of severity of other inhumane acts, that you shouldn't leave it to the imagination of perpetrators to find a way of torturing or a way of persecuting a civilian population by they can do something that there is no codified crime, no previous jurisprudence on. So the courts have found that forced marriage does reach the level of another inhumane act in Sierra Leone. I think the elements will be the same in Cambodia, and the Cambodian courts will apply as those that the courts in Sierra Leone applied. The phenomena was different. And one of the big phenomena, the real big differences is in Sierra Leone, as Joseph mentioned this morning, the wives were often a reward to fighters. So the men were given the reward to have a wife to do the domestic chores and for sexual purposes. In Cambodia, it was very different. The government had a policy, I would say, of controlling family life, limiting family ties, and so they decided that they would select spouses, and both the man and the woman were victims of the forced marriage. Men were given no choice about who they had to marry any more than women were. One of the witnesses that testified last month was a transgender person born as a man, identified herself as a woman, but forced during the regime to marry a woman, and then forced to consummate that, and it actually produced a child, that union. So it's a very different phenomena in Cambodia because it was a government policy about just controlling the society completely as opposed to a reward to fighters.
Okay. Do you want to add anything, Brenda? Or?
Just that I think initially we have to look at whether this is a new crime or not. And I know this term is used even by the judges at the special court. But in my mind, it's not a new crime. What it is a new characterization of certain conduct as an other inhumane act, which is not a new crime, other inhumane act. But in the situation in Sierra Leone, it was actually a dissenting opinion in the AFRC case, and the judge in the dissenting opinion said that what had happened with women and girls in Sierra Leone is that they had vitiated the will of these women and girls and forced them to enter into and remain in a marital union. And by doing this, they subjected the victim to physical and mental suffering. And they relied on the two substantive elements of other inhumane acts, which basically are that the perpetrator inflicted great suffering or serious injury to body or mental or physical health by means of this inhumane act, and that the gravity, as Nick said, was similar to the other articulated crimes. And in this dissenting opinion, the judge said, I understand that forced marriage has not been identified as a separate crime, but when we look at the spirit and other provisions of treaties and conventions, and also when we look at domestic jurisdictions, we find that there is in many of these treaties, conventions, and domestic jurisdiction a requirement that, quote, marriage be with the consent of both parties. And so there's a basis for saying that where this consent is absent with one party, then we have potential criminal conduct. The appeals chamber upheld the dissent and overruled the majority, and in doing that, the appeals chamber basically said that forced marriage shares certain elements with sexual slavery, to include non-consensual sex and deprivation of liberty, but they said, in addition, forced marriage describes a situation in which the perpetrator compels a person to serve as a conjugal partner, resulting in severe suffering or physical, mental, or psychological injury to the victim. And in relation to, well, is there notice to the perpetrator that this conduct is criminal, the appeals chamber said that they were satisfied there was such a notice because they said what we had in Sierra Leone were perpetrators who intended to force a conjugal partnership upon the victims, and they were aware that their conduct would cause serious suffering or physical, mental, or psychological injury. And in arriving at this conclusion, they looked at the underlying facts of the situation in Sierra Leone for women and girls. And that basically was abduction, often with severe violence. And part of that abduction very often included rape or serial rapes at that time, and it was only later that they were handed off. That it also included forcing these people to move with the force from place to place, to perform basically slave labor for their husband or the perpetrator who had them, and also to bear their children and raise them. So they said, when you look at the underlying conduct, we're satisfied that these individuals intended this conduct and they must have known that this was criminal in nature. Now, one final point that I think is interesting is that in the Taylor case, we did not charge forced marriage. And there were two reasons for that. At the time we began to present our evidence and were preparing the last stages of our case, forced marriage was upheld in a dissent in the case, and the majority had said that is not the proper characterization. And it was only after we had begun to present our evidence that the appeals chamber upheld this dissenting opinion. And we felt at that time it was too late to amend an indictment to include forced marriage. But in my mind, there was a more important reason for not including forced marriage, because in my mind, the situation in Sierra Leone had nothing to do with marriage in any form. It was a form of enslavement, which was both sexual in nature and also forced labor in nature. So we didn't charge it. So that meant that the trial chamber had to deal now with our case in the context of previously having the appeals chamber uphold forced marriage. And all three of the judges, including the judge who had dissented in the AFRC case, said that we reflect that marriage is not the proper characterization for what happened here, and that forced marriage is not the proper characterization of this underlying conduct. That really what it is a form of sexual slavery that involves conjugal duties, which basically are domestic duties. And so they went back to this analysis and said, we think that it was a misconception. And of course, as trial chambers are wont to do, they said, and it was forced upon us because, of course, the prosecution charged forced marriage, so we had to deal with it. But we think more properly it is not a situation of forced marriage. And so they upheld the same conduct as sexual slavery with this added component of conjugal duties, and that was not an issue on appeal. So that's how we dealt with that issue.
So up to this point, we've been talking about the substantive law legacy of Nuremberg and the tribunals. Let's look at the efficacy legacy of the tribunals. And, you know, most people don't focus on the fact that Nuremberg acquitted 3 of the defendants. So the radio broadcaster, Fritsch, the banker, Schacht, the former Vice Chancellor von Papen, they were all acquitted of all charges. The Yugoslavia Tribunal, Serge, has had several recent high-level acquittals. And probably the most visible one is the case of Václav Sežel in March. What can you tell us about that decision and how you think it reflects on the legacy of your tribunal?
I think it's a very bad decision. I can give a little bit more details if you No, more seriously, this has been our nightmare trial for the last 10 years, and which was very much reflecting also the inability of some of the judges to really handle this case of a self-represented accused who has been, during the trial, has been convicted several times for contempt of court, for interference with witnesses, for publishing the names of protected witnesses. So he was convicted in total for 4.5 years in 3 different trials for contempt of court. And by the way, we have still today 3 pending international arrest warrants against 3 members of his defense team who should have been arrested by the Serbian government already 1.5 years ago. And this will be again the subject of a lot of criticism from the tribunal towards the Security Council against Serbia for non-cooperation.
The other part of the efficacy of the tribunals is their ability to actually get custody over the accused. And Nuremberg didn't have much of a problem with this. They didn't need a constabulary because they had a bunch of armies that were occupying Germany that could go around and pluck people up and bring them to the tribunal. But the ICC and the ad hoc tribunals depend on the cooperation of states, the Security Council, and the Assembly of State Parties. So let me ask Serge, Hassan, and or Brenda, notwithstanding the lack of a constabulary, your 3 tribunals, the Yugoslavia Tribunal, the Rwanda Tribunal, the Special Court for Sierra Leone, ended up gaining custody over nearly every indicted person. And I have to say I'm one of the most surprised, pleasantly, about that. What was the secret to the tribunal's success in this regard, and what are the lessons for the ICC? Brenda, sure. Yeah, any of you.
You know, earlier we heard an excellent presentation, and they talked about the political environment post the Second World War that allowed the creation of an international justice mechanism, and spoke about it as a shining moment. And it was decades later that we had other such shining moments, but decades later, the political environment was such to allow the creation of new international justice mechanisms. And that was the ad hoc tribunals and then the follow-on courts from that. And another shining moment was when states came together to create the International Criminal Court. And the reason I preface my remarks with this is that our success depends upon the political will of the international community. And certainly in Sierra Leone, we are talking about the government of Sierra Leone. And we would be remiss if we did not thank and acknowledge the tremendous cooperation that we received throughout the life of the court from the government of Sierra Leone, even when we indicted individuals who were viewed by many of the population in Sierra Leone as saviors of the democracy and national heroes. The government of Sierra Leone assisted us in arresting these individuals and transferring them to the custody of our court. So we had that political will in Sierra Leone. Where you do not have that political will, then you do not get the people you indict. And that was an instance in the Sierra Leone court as well, where we did not have the political will, and we had to wait until the political will was there to get this indictee, and I'm talking about Charles Taylor. Now, the political will of the international community is beyond the power of the courts to create, but there are things that courts can do to try to encourage and to build this political will throughout the world. And certainly in Sierra Leone, David Crane, the chief of investigations and the deputy chief of investigations, worked very diligently to establish very good working relationships with the Inspector General of Sierra Leone. And it was in part because of this good working relationship that they were so cooperative with us in effecting the arrest and transferring these people to us. So that is one way that we can try to build this international political will. Also, at a lower level, having our people work with lower level authorities in the appropriate agencies also assist in building this political will. And beyond that, as I think the other tribunals have noted, building an effective tracking unit so that you can locate where these individuals are in the world, establishing good relationships with the authorities there is also another means that we can help to build this political will. But one thing, and I think the Yugoslav Tribunal did this best, is that there comes a point where you simply have to name and shame. And you have to make very public what you have done and who it is that is blocking your ability to get custody of these people. And in that regard, you also, I think, have to analyze what is it this state wants, this non-cooperative state wants from the international community, and how can we energize the international community to make getting what they want conditional on handing over people. So those are some of the ways I think that we can build political will, but ultimately this is an issue and a failing of the international community, not the courts.
Serge, do you want to add something?
Yes. Yeah, we are in this lucky situation to be probably the only tribunal with no fugitives at large. And as Brenda said, we had a very successful tracking team with Bob Reed, an Australian investigator, being really our best fugitive hunter, if I may say. And I would like to say that the main reason is that we have done a fantastic job and that we're excellent. But the real reason is that we have the European Union and the conditionality policy in the early years when Milosevic was arrested but not surrendered. But it was the US was planning and organizing a big donors conference who insisted on the transfer of Milosevic, who was surrendered one day before this donors conference for Serbia was taking place. When I took over 9 years ago and Karadzic and Mladic were not arrested, I had not only to report to the Security Council every 6 months, but also to the Council of Ministers of Foreign Affairs of the European Union, and every time our report was negative, Croatia, Serbia, Bosnia would not move forward in their EU progress. So for me, it is crystal clear that this stick-carrot policy by the European Union towards the countries of the former Yugoslavia has played a very key role, because it was a very clear political agenda. You want to join the European Union? There are a number of criteria to be fulfilled. And I remember that in 2011, a few weeks before Mladic was arrested, there was a survey done in Serbia where 65% of the people interviewed were against the arrest of Mladic, which we spoke about outreach earlier today. You know, there have been videos in the courtroom, videos shown in the former Yugoslavia where Mladic's men are executing prisoners. But despite these very obvious documented crimes, a majority of the population still consider all of our war criminals as heroes. That's another problem. But so 65% were against his arrest, but 75% were in favor of joining the European Union. And politicians are everywhere in the world very similar. They very often do what they think will have the most important impact. And this is missing for the ICC and other places. Look at the ICC and the Security Council. Countries cannot agree of having one political line. In the majority of countries where the ICC is coming in, you know, you have one side and another. So my conclusion in this regard is, and I agree with Brenda, it's much more the failure of the international community that there are no arrests, because the ICTY has demonstrated that there is a common political position with a very clear agenda. Justice is successful, and in the other parts, it's much more complicated.
Hassan, did you want to add something briefly?
Yes, well, these indictees have to be arrested because all of us, I think with the exception of maybe Lebanon, in all our cases, you can't have trials in absentia, so you must bring in the accused person. And in the case of the Rwanda tribunal, unlike again in Germany here at the time, none of them was present in Rwanda. All of them had fled the country. A couple of them were present enough to actually get engaged as part of the defense team in the ICTR, and were caught on our premises in Arusha itself. So 3 things we found very, very useful. One is setting up a tracking team of very efficient, competent, dedicated investigators who carry out the very difficult task of trying to track the movements of these fugitives. I think that's an important lesson. The second is that the tribunal engaged very much in diplomatic outreach to secure the cooperation of states. Because once you track the fugitive and you find him in a particular location, we didn't have any powers of arrest. You still have to fall back on the country concerned to effect arrest of the accused. So diplomatic outreach was very, very important, and we did this at various levels on a bilateral basis with the country concerned. At a regional level, working with countries in the region to put pressure on some of these defaulting countries. We worked with groups which constituted, or states which constituted themselves into friends of the ICTR, and they spoke on our behalf with regard to some of the difficult countries. In the final analysis, we went back to the Security Council. We went to the Security Council and secured its urging of the states concerned to cooperate with us, particularly Kenya, with respect to the case of Kabuga. These were some of the methods we resorted to. And finally, of course, a little bit of good luck always helped us. We had some very, very lucky arrests, I must tell you, when you know the circumstances under which these were effected. At the end of the day, of course, we had indicted 93 people, all of whom were arrested, except the 3 we have now passed on to the mechanism. And so it's the task of SARG now to look for them, find them, and bring them over to Arusha for trial.
Now, Hassan...
And with the exception of 6 more, we sent to Rwanda for trial there. And it's the responsibility of the Rwandese to prosecute them.
Hassan mentioned the Lebanon Tribunal, which is the only tribunal since Nuremberg that has the ability to do trials in absentia. And as you know, students of Nuremberg, Martin Bormann was prosecuted in absentia, and it turned out after the trial and his conviction that he actually had been dead, which was a little bit of an embarrassment. Now, Eckhart, we didn't forget about you down there. You're not a potted plant. Can you tell us a little bit about how the trial and absentias are going? And I understand that one of the defendants that you have indicted in absentia, Mustafa Badreddin, who is a leading Hezbollah commander, he was actually killed in an airstrike this past May. And so your office is actually in the middle of a debate about whether he should be the modern-day Martin Bormann. Should you prosecute him even though you know he's dead, or drop him from the prosecution? Tell us a little bit about that.
Sure. First, I want to repeat that I'm talking on behalf of the prosecutor, Mr. Norman Farrell, who sends his regards and apologizes
Put right up.
Apologizes for not being able to attend due to other work
Really
commitments.
close.
In respect of the accused Badreddine, what has happened is the following. On 30th of May, we got a number of reports indicating that the accused Badreddine, as all the other 4 accused being tried in absentia, was killed in an airstrike in Damascus, close to Damascus in Syria. Who is Badreddine? Badreddine is, in essence, a senior Hezbollah military commander, if not even the most senior Hezbollah military commander. At the time of his death, he was commanding the Hezbollah troops in Syria supporting the Assad regime. Badreddine has been involved for decades in operations of Hezbollah, including in a number of assassinations Hezbollah has done over the decades, and he was always a key figure in these assassinations. Badreddine's role in our indictment is simply characterized by saying that he was playing a leading role in preparing and executing the attack, the assassination of Rafik Hariri, the former Lebanese prime minister. What followed the reports of Badreddine's death and continues to be is a rather peculiar aspect of litigation that's still going on. It took the trial chamber, and this is clearly related to the fact that it's in trial in absentia. It took the trial chamber and the appeals chamber almost 2 months to judicially determine that Badreddine was dead and to terminate the proceedings against him. The proceedings are terminated by now, so we are not prosecuting Mr. Badreddine anymore. And of course, we amended the indictment. We continue to name him in the indictment as an unindicted co-conspirator, what has caused a lot of trouble with the defense, but relying on ICTY jurisprudence and other international jurisprudence, we were easily in a position to convince the trial chamber that this is the proper way to proceed. What we are facing now makes it even more complicated, and we thought after the trial chamber has agreed to the amendment of the indictment, that particular aspect is finally be dealt with. But what happened just recently is an order of the trial chamber where the parties have been invited / ordered to make submissions on the question as to whether an amicus curiae should be appointed to assist the trial chamber by the amicus curiae assisting defense counsel to address the evidence that relates to the now dead accused Badreddine. One really needs to understand what that means. And of course, our submissions will be very clear for a number of reasons. First of all, it is unnecessary, it's unhelpful, it's unpractical. They're unpracticable. There's no precedent in international criminal law. To our knowledge, there's no precedent in any domestic law. And we are hopeful that the trial chamber at the end will follow our position, but there's certainly no guarantee. The mere idea that there would be an amicus curiae appointed who, in essence and in practice, does nothing else but what an appointed defense counsel does is a bit of a difficulty for us to conceptualize, and we hope it's not going to happen.
So another innovation coming out of another tribunal. This is called the IHL Dialogues, and you're hearing a dialogue among the prosecutors, but I think what many people love about this panel is the ability to ask the prosecutors your questions. So even though I have a lot of other questions, and I'm sure some of you wanted me to address them, let's turn it over now to the audience so that you'll have a full 15 minutes to ask your questions. And I'll just point, and is there a microphone down there, Jim, for people to ask questions? Let's do that, and then someone will share. Okay, so if you have a question, just raise your hand, and Jane Stromstad. Just wait for the microphone, which is coming.
So I know that many of the tribunals have engaged in meaningful and systematic outreach with affected communities, because part of the International Justice Project is not only doing justice through fair trials and holding the most responsible accountable, but also conveying and demonstrating to victim communities that this is being done, and also honestly engaging with their criticisms. Maybe they think those most responsible are those who live down the street and were not prosecuted. So I'm interested in your thinking about outreach and how that's being done, how it could be done better, the field presences and so forth, that aspect of dealing with the affected communities and their demands for justice. Thank you.
Well, one or two of you address that? Fatou, without a microphone, can you just hand the microphone down? There we go.
Outreach is critical to our work, I think to the work of any tribunal, but particularly we have seen that to the work of the ICC, we just need to do outreach. One of the problems that we have encountered is the fact that the court is not known, it's not understood, the jurisdiction is not also properly understood. Why we intervene in certain areas and why we don't intervene in others is also not known. So it's, and of course what this creates is this perception of bias, for instance, that you're trying this person and you're not trying the other person, or you're in this region and you're not in another region. And as I said, this is largely as a result of perhaps not engaging in enough outreach, not being out there explaining what the court is actually doing and what we're engaged in. And we have reflected a lot on this at the level of not only my office, but at court-wide level. As you know, currently, the way we're set up is that registry is primarily responsible for outreach. But it is important that, of course, where we can, as Office of the Prosecutor, we also get involved in those messages to be conveyed. Because there are certain things that the OTP can do or can speak for themselves, which unfortunately the registry cannot do by themselves. So with this, with the recent changes that the registry has made, includes more field presence and also having people, staff at a very senior level who will also be able to be in the field and be able to answer to those questions. I don't know why this is not going away. and we also, as an OTP, we're looking into it. Another thing that the registry was doing, and which I think paid off very well in both the Lubanga trials and the Katanga, and which we are repeating, is ensuring that we have like this video
like a documentary?
The fact that we can have in the field a video or a screen in which they can follow the trials directly. And also, we do have people now from the registry who are also able to be out there and to answer questions directly with the affected community. One of the things that I did also was to try and get to be closer to and engage more and interact more with civil society. I think it is important, them being the first responders, they will also be able to convey the messages from the Office of the Prosecutor, but also from the registry and from the court at large. We also try to engage as much as possible with states themselves, states parties themselves, who are able to at least organize some of these events on the ground, where we will be able to be present. The court, all the organs of the court represented, we call them the cooperation events or the cooperation seminars. We have so far had quite a few on the African continent, but also outside of the African continent. In fact, in this coming month, we hope to have one in Chad. We're working on it. So these are some of the efforts that we are making to get closer to the people, to be able to explain to them what the court is doing. why the court's jurisdiction is the way it is, and also to explain why we cannot intervene in all areas, because the expectations for the court is very, very high. This is also something else that is really affecting us. Very, very high, and it is felt that whenever there is conflict anywhere, the ICC should be there, should be present. As I said earlier on, we've got a lot of requests and information and about why are you not intervening in Syria or in Iraq. And of course, it is not that by choice, but the fact that our jurisdiction is limited to that effect.
Can I ask a follow-up to Nick? Nick, there's a recent OSI report that indicates that the Cambodian people are receiving very little news about the Cambodia Tribunal from the media. Is this undermining your outreach and the educative function of your trials?
I think that was Laura McGrew's report that recently came out. Of course, it's difficult. It's a rural society, and some of the rural communities are quite isolated with limited media. In Cambodia, for example, radio is probably more important than television, although that is changing. But one of the great advantages of having a court in the country is, to date, over 200,000 Cambodians have come through and witnessed proceedings in the courtroom. We have a very large courtroom that seats about 500 people, and pretty much every day there's a group of at least 100, sometimes several groups, hundreds, that come in and watch a bit of the proceedings and get some briefing on what the court is doing from the outreach people. But clearly more could be done. There were more television programs and then the money ran out. There were more radio programs and the money ran out. Still every day in the press in Cambodia, both in the English press and in the Khmer press, there are articles about what's happened in the court and in the trial.
Now, we're running out of time, so maybe if 2 or 3 people would each say their question, and then we'll just hear those questions, and then we'll allow the bench to decide which ones to address. So let's start, just tell us your question real quick. The microphone is coming toward you. And we'll just do your question. We'll wait for a second to have a couple more questions, and then we'll...
How prosecution and indictments could look like in the future if we don't deal with states anymore, but with ideologies. Like extremists do not believe to rely on states, but to an ideology which is unifying them. So you see you see terrorist groups in Syria, Iraq, Afghanistan, but they belong to all kind of nationalities. So how this could look like in the future, and what impact the ICC could have on that.
Okay, so that's one question, and your hand is up.
Hi, Eva Vukušić from Utrecht University. I have a question for Prosecutor Bensouda and Serge Bramertz. What would you say to an idea one day of an ICTY modeled tribunal for Syria? Would that be something that you would agree to or sort of oppose? I'm really curious because people say that arguing for that undermines the ICC, and given that Prosecutor Bramertz, you're from the ICTY, I'm wondering what your thoughts are. And as a former Yugoslav, thank you for your work, Prosecutor Bramertz.
Okay. And another question there.
My question is about the notion of political will and the opportunity to execute the judgments you make to bring through the sentences and possible incarceration. I'd be interested to know how important this is and how do you accomplish it?
Okay, and then the last question, you've been patient. It's coming.
Patrick Labuda, Graduate Institute. I just wanted to ask, I know you're all extremely busy. And so what role does academic scholarship really play in your decision making? Do you have time to engage with some of these academic criticisms, or maybe just how do you deal with this? Thank you.
So we have about 2 minutes. Hopefully, if your question isn't answered now, you can get it answered after the panel. But we do have 4 questions, and if any of the panelists want to try to answer any or all of those very briefly, that would be great. Sarah, do you want to try to start with?
I can start with
the ICTY for Syria.
ICTY for Syria. Again, it's a big political debate. I spent 2 years in Lebanon when I was in charge of the Hariri investigation, the opportunity to interview President Assad and many others in the context of this investigation. And believe me, former Yugoslavia is a complex area, but the Middle East is not very different in many regards. We all know that 4 times the Security Council resolutions failed to send the case to the ICC, but I think that independently of a referral ever, the ICC alone will never ever be the solution for Syria. You have already twice as much victims as you had in the conflict in the former Yugoslavia. The conflict is already twice as long. We have indicted 161 persons at our tribunal. There are 5,000 people still in investigation, under investigations in Bosnia. So to think that the ICC alone would ever be the solution for accountability in Syria, no. What would be the best model? Of course, I think the closer you are to the people affected, victims communities and perpetrators communities. We spoke about outreach to the victims, it's one thing, but outreach to perpetrators communities, I think it's a big challenge. So I'm in favor of an ad hoc solution, not necessarily an ad hoc tribunal, if possible, with local ownership, because once you have serious local ownership, you have already less room for criticism because people cannot distance themselves. But it will be extremely difficult to find people who will be willing to engage in a mixed solution. Very briefly, I remember when I started in Lebanon, I had 5 investigators, I had 20 posts. I invited 10 ambassadors from all Middle East countries from the region to ask them to make lawyers and investigators and prosecutors available. 5 of them said, well, you know, we are so honored that you are asking us, but we don't have any people who are qualified to join your investigation commission. The other 5 were saying, well, let's be honest, we don't want to touch this Hariri investigation commission. So as much as I'm in favor of a mixed solution for Syria, it will be extremely difficult to find people who are willing to do it and who are perceived as independent and impartial enough by the others to have the necessary credibility.
Now, Fatou, you mentioned academic scholarship last night in your speech, so let's let you have the final word, and maybe you can answer that question about being busy and the role of academics.
I continue to say that it's really very important for the ICC, the work of the ICC, to have this discourse and this discussion that takes place at the academic level. Of course, it does not make us decide on our cases. I thought I heard you say that, how does it help you in your decision making? With respect to the cases themselves, of course, we have to follow what the Rome Statute says, what the law says, and how we can charge in respect of these crimes, which are already, as you know, laid out and defined. But their importance, the importance of academics and the discussion that they hold about the work that we do, or even the discussion that they hold with respect to the various provisions of the Rome Statute, which guides us, is critical. It's very, very important for us. And I have acknowledged it several times. I have said that this is something that we hold as very critical to the work that we do. There was the question about ideologies and some of these perpetrators who now commit crimes based on ideologies or states. But I just wanted to remind that with respect to what we do, it's about individual criminal responsibility of individuals who commit these crimes. And it is those, and there are various means in which people reason why they need to commit these crimes. It can be ideologies that they have, it can be based on policies that they have, but at the end of the day, what is crucial for prosecutors to look out for is to see whether the elements that we need, that the elements that are required, and that these individuals who perpetrate these crimes, whether they fall within what we are actually looking for. So currently, if you look at even the case docket of the ICC, you've seen that we've charged people who are from the, state actors. We've charged them at the highest level. but we've also charged people who are in the militia. So, and if you look at both of them, you see there is, you can see it's perhaps policies of states that has made them commit these crimes, but also with respect to the militia, it was what they believe in. That is why they go forward to commit these crimes. So I don't see it being different in the future, as long as you stick with the principles of what your statute tells you, what the law tells you in respect of the crimes, whether these elements have been satisfied or not. I hope I have understood your question. Then there was the one with respect to, and Serge, we've already answered that one with respect to whether ICC will be undermined if there are other courts that are set up with respect to Syria. I don't think so. Firstly, you should also remember that the ICC is a court of last resort in the first instance. It's not here to replace national jurisdictions. It comes in when national jurisdictions are unable or unwilling. In the current case, I can only say that I don't even know whether I can comment that far, given the fact that neither Syria nor Iraq is a state party to the Rome Statute. But as I said earlier on, I know that there are various attempts, there are various initiatives that are taken by states to try and get the ICC involved, have jurisdiction in respect to that. But until that happens, currently, I don't want to go again into what I've already explained with respect to personal jurisdiction, but currently we do not have here. And you know, I have said it before that it's important that justice is done. At the moment, it is almost impossible or very difficult for the ICC to come in. But that should not stop other efforts that are being made to ensure that justice comes to both Syria and Iraq.
I'm getting hand signals from Jim Johnson, so we're going to have to wrap this up because it's lunchtime. Please join me in a very warm thank you and applause for our panel.
Thank you to our prosecutors. I watched them setting up lunch a minute ago, and I almost went ahead and started without you. But we do have lunch being served in the break room. Now, it appears on your schedule that you have in half an hour to go get lunch and eat lunch, and that's not necessarily true because you will notice at 1:30 we are having our luncheon keynote address. So go and get your lunch. And if you're not finished at 1:30, please bring your lunch in here with you and enjoy the remainder of your lunch while we listen to what will be a very, very wonderful address starting promptly at 1:30. Thank you very much.
What?